Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi, everyone. Thanks for joining this episode of the Immigration Lawyers Podcast. I'm here with immigration attorney and, constitutional scholar, Sabrina Damast. We're going to go over this big Supreme Court decision that relates to Kaiser v. Wilkie, which is about the idea of Auer Deference. We all heard of Chevron deference when we deal with immigration stuff, but there's also Auer Deference. We're going to go over the differences and what that is. So you get starting with what it means, and then we'll go to what the court said. I thought it'd be important to know because it affects us because we deal with so much administrative law in immigration field and all the specific world that we're in. So I thought it'd be good for listeners to understand what happened and know the facts and in which direction the court went. It's very interesting. The split that happened in the court shows there's just all over the place right now. But Sabrina, thank you so much for coming on board.
Oh, thank you for having me, John. It's my pleasure to be here with you.
Thank you. So I'm not sure, there's so much to talk about because it's a complicated case, but could you just, where do you think we should start?
So I think it's actually really good to just sort of start with a background of what this whole concept of agency deference is and when does it come up. Sure. So agency deference is the idea that when an administrative agency, right? So for example, the Department of Justice, the Veterans Administration, the Department of Homeland Security, the EPA, when they write their own regulations, as they very frequently do, and then interpret those regulations, there is an idea in case law that their interpretation of their own regulations is entitled to deference. And this really comes out of the idea that agencies deal with highly specialized areas, complicated areas, right? So for example, the Environmental Protection Agency, the EPA, they deal with environmental regulations. And the idea is that they probably staff environmental scientists on their payroll. And so if there's a question about what a regulation that the EPA promulgated means, right, what a certain term means, what the intent of the regulation was, the expertise of those environmental scientists is probably better suited to interpreting the environmental regulation than a bunch of federal court judges. Mm-hmm. Now, this is kind of funny for folks like you and I. We work in immigration law, and there's no such thing as like a person who has an immigration specialist, background that isn't a lawyer, really. I mean, It's true we have adjudicators in the immigration world that are not lawyers, but generally anything that we differ with the agency on a definition of is usually a legal term. So this whole concept doesn't work so well from the get-go in immigration, but that's where the idea comes from. And in the decision, the Kaiser versus Wilkie decision, Justice Kagan actually gave a number of really interesting and illustrative examples of where this type of interpretation comes up, right? So I'm just going to go through a few of them. Sure. So that people have a sense of where these issues of deference may arise. So the first example she gave was something to do with the Americans with Disabilities Act. Under the ADA, the Department of Justice requires that theaters and stadiums provide people with disabilities, quote, lines of sight comparable to those for members of the general public. And so then Justice Kagan poses the question, must the Washington Wizards construct wheelchair seating to offer lines of sight over spectators when they rise to their feet? Or is it enough that the facility offers comparable views so long as everyone remains seated? And she didn't come up with this. This is actually a district court case that came out of the Central District of California that evidently involved the question of what it means to have a line of sight comparable to those members of the general public for disabled spectators at the stadium. Another example, one that probably all of us have had to think about way too often, right? The Transportation Security Administration, it has these rules about liquids and gels. You can only have them if they're smaller than 3.4 ounces and they're in a plastic bag if you want to have them on a carry-on. There was a case that arose in the Western District of North Carolina about whether the issue of whether truffle pate qualifies as a liquid gel or aerosol for the purposes of these rules about carry-on luggage. Truffle pate. Who knew you were going to litigate about pate, right? So another example, right? The Food and Drug Administration. They give pharmaceutical companies exclusive rights to drug products if they contain, quote, no active moiety that has been approved by the FDA in any other new drug application. I hope I'm actually pronouncing that word right, because I have no idea what it is. And so and apparently I may not be the only one who's not familiar with the terminology, because there was, again, a case out of the Court of Appeals of District of Columbia about whether or not a company has created a, quote, active moiety by joining a previously approved moiety to lysine through a non-ester covalent bond. I think you need a chemistry background just to understand what the question was. But again, the focus here is, what does it mean to have an active moiety, whatever that may be, that isn't, that hasn't been approved in a different drug application by the FDA.
Okay.
So the idea, right, well, maybe the FDA is the best example, right? The FDA, they employ, hopefully, chemists who understand what that is. They have a better idea about what the context of active moiety might have been in the regulation than a district court judge or a federal appellate court judge. And so the idea was, we would give deference to the FDA's interpretation of that regulation as long as it's not unreasonable. So the issue, though, only comes up, right, if the regulation is what is what we describe as ambiguous, right? If it's susceptible to more than one interpretation. I mean, if everybody knows what an active moiety is, then nobody will ever have to litigate the meaning of that phrase in a federal court. So the first question in an agency deference case is always, is the regulation, or if you're in other aspects of agencies, is the statute. We call that Chevron deference instead of Auer deference.
Oh, so quickly, what is the difference between exactly Chevron deference and Auer deference?
So Auer deference has to do with when an agency is interpreting its own regulations. Chevron deference is when an agency is interpreting a statute that it is charged with administering. So if you want to look at the immigration world as an example, if the Department of Homeland Security or the Department of Justice, or maybe the Department of Labor, if you do business immigration, is interpreting something in the CFR, right, 8 CFR, whatever, it would be an Auer deference question because it's a regulation. But if they are actually interpreting the Immigration and Nationality Act, right, terms of what's a crime involving moral turpitude, for example, right, an INA 212 A2 A1, that's a statute, and it would be a Chevron deference question. So it's just whether or not the agency is interpreting a statute or a regulation that it administers.
I see. And right now, the standard for Chevron is pretty similar to the Auer deference, like siding with the government's interpretation?
It had the same layout, right? You always look at whether that's in the statute or the regulation is ambiguous, and if it is, then you ask if the agency's interpretation is reasonable, and if so, you defer. So it's the same kind of presumption, if you will, that the agency, is right if you're in a disagreement with them.
Yeah.
And I have to say, I think it's not unfair to say that historically, even when they were asking the first question, right, is this regulation or is this statute ambiguous, the government often got some deference on that too, right? If you read some of the case law, you start to get the feeling that if the government has a different interpretation than you do, then it must be by definition an ambiguous statute or an ambiguous regulation.
Yeah.
And so you would always end up at what we called, what they referred to as, Auer or Chevron step 2, which was the question as to whether or not the agency's interpretation was reasonable. And that is where I think the first place where the Kaiser versus Wilkie decision is really a game changer here, right? Justice Kagan starts with the proposition, what should be a sort of, a non-controversial proposition, but really I don't think is played out so non-controversially in the history of agency deference, that not all regulations are genuinely ambiguous. She really implores the lower courts to not simply say, okay, well, the agency says it means X and the other litigating party says it means Y, it must be ambiguous, but to use all of the tools that a court has for interpretation at their disposal to really determine if the regulation is in fact ambiguous, right? So she talks about things like looking at the regulation in its greater context, right? Its greater, the rest of that paragraph, right, that it's in, or the rest of the section of regulations that it's in. She really, and she talks about things like looking at the history of the regulation, right? Presumably, I mean, if you were looking at a statute, you might look at legislative history, but I think in the regulatory context, maybe you're looking at, comments that were made during the publication of the regs, during the process of publishing the regs. But really, she really starts by saying we can't just accept that all of these things are ambiguous, right? She says, for again, only when that legal toolkit is empty and the interpretive question still has no single right answer can a judge conclude that it is more one of policy than law, right? I really enjoyed that sort of, the idea of the toolbox, right? The toolbox of statutory interpretation. So, I think Justice Kagan is really imploring the lower courts to take step one of this analysis a little bit more seriously, a little more in-depth and detailed conversation and analysis about whether this regulation is really susceptible to more than one reasonable interpretation. Because if it's not, right, if there's nothing ambiguous, if the definitions of the litigated terminology are really clear once you look at them in all of these larger contexts, then you don't get to the issue of agency deference, right? There's nothing to defer to if it's not susceptible to more than one interpretation. So that was the first big point I pulled out of this case, right? The idea that not everything is ambiguous. But then there were some other considerations she really hammered home on, right? And one of them was, and I think this one may be particularly important for immigration practitioners, right? That not everything is not everything in the regulatory scheme of an agency is necessarily something that Congress would have wanted deference to to the agency, or would have wanted, I should say, that deference be accorded to the agency in interpreting. And again, this sort of gets back to the idea of whether or not the agency truly has expertise in this area that is not possessed by, say, your average district court federal judge, right? And again, it works well in, say, the EPA context. It may work well maybe in the TSA context if it's an issue of security. I think it works a lot less well in the immigration world because we don't have technical expertise in the immigration world that is apart from the law itself, right? Our technical expertise is an understanding of immigration law, as opposed to things like the Environmental Protection Agency, where the technical expertise is in environmental science, right? How to protect the environment, what kind of things pollute the environment and damage the environment. And so, there was a part of the decision where Justice Kagan says, when the agency has no comparative expertise in resolving a regulatory ambiguity, Congress presumably would not grant it that authority. And she's actually talking here about legal terminology, right? So she's saying, if you're actually just interpreting a legal term, then your judge is probably as qualified, if not more qualified, maybe. I don't think she says it that way, but that would be my thought, right? To interpret that legal term as anyone in the agency. And so, in the immigration world, what do we fight about with the agency? What is the definition of a crime involving moral turpitude, right? What is the definition of a specialty occupation for an H-1B? There's nothing but legalese that we fight with in the immigration world, at least that I can think of offhand, where you get issues of agency deference. And so I think this is also a really powerful tool for immigration litigators to be using, right? To say that, you know what, there's Jeff Sessions, William Barr, they have no more expertise in understanding the term crime involving moral turpitude than you, district court judge or federal appellate judge, have. And therefore, this isn't an area where Congress would have wanted, Jeff Sessions or William Barr to somehow have more influence over the interpretation of the law than a federal court would have.
Very interesting. So there was, and this is the final language, so that this could be used in, future litigation.
Absolutely. And there was one more really interesting point to me about this. So there's a section where Justice Kagan talks about disrupting expectations, right? If the interpretation by the agency would disrupt settled expectations of individuals impacted by the regulation, then that's probably not an area where you would defer. So she says, a court may not defer to a new interpretation, whether or not introduced in litigation, that creates, quote, unfair surprise, unquote, to regulated parties. That disruption of expectations may occur when an agency substitutes one view of a rule for another, and we therefore have only rarely given our deference to an agency construction conflicting with a prior one. So, I mean, I'm sure you have experienced in your employment-based practice, right, sudden shifts, right, where USCIS suddenly says something that was fully acceptable before to demonstrate a legal qualification is no longer acceptable, right? Or
every week since this year, it's every week from O's to L's to H's, everything, yeah.
And I was thinking, I'm not sure this is a totally on point example, in part because it doesn't, it was sort of part regulatory, but part, judicial history, right? I was really thinking about the Attorney General's decision in matter of Castro Tum to more or less abolish the concept of administrative closure in immigration court. And while I'm not sure yet that I could formulate an argument about how Kaiser versus Wilkie impacts the legitimacy of that decision, it certainly would be a great example of a time where the Board of Immigration Appeals, right, suddenly shifted dramatically an interpretation of law in a way that disrupted the expectations of individuals who are in immigration court proceedings, right? For when did the provisional waiver regulations come out? 2013, I think, right? So from 2013 until 2018, people in immigration court proceedings who would qualify for a provisional waiver of unlawful presence had a pretty secure expectation that they could get their proceedings administratively closed, as was required to pursue that waiver. And of course, well, I know you don't do court work, but I'm sure you've heard from your colleagues like me who do court work that is not possible anymore because of the decision in matter of Castro Tum.
It's like a race against the clock. You got to get that waiver approved before they do a final order or something like that?
Well, you actually have to get it filed before they put the person in immigration court proceedings at all. The regulation specifies that you're only eligible to apply for a provisional waiver if you're in removal proceedings, if those proceedings are administratively closed. And so everybody in proceedings, the moment that matter of Castro Tum came out, lost whatever eligibility they may have had to pursue a provisional waiver of unlawful presence. After a solid 5 years of them all having the ability to apply for it because of the existence of administrative closure. And so, I mean, I think this is pretty pervasive right now. I mean, I've definitely heard from my employment-based colleagues that, USCIS seems to be flipping switches back and forth, left and right. What is a specialty occupation? Prevailing wage issues, you're telling me O's and L's and things that you work on.
Definition of a manager, definition of executive. For O's, like what standards they have for every aspect of what they consider extraordinary ability, and same with EB1A extraordinary ability. So it's like it makes it almost impossible to practice this area because there's no standards at all at this point.
I mean, I think people who do consular processing are probably having a similar feeling with the public charge ground of inadmissibility, right? It used to be you had your petitioner made 125% of the poverty line, there were no more questions asked. Or if your petitioner didn't, you got your co-sponsor, and it didn't matter if they were a sibling, an uncle, a cousin, a neighbor, an employer, whatever, right? As long as they earned enough income on the I-864, on the affidavit of support, no questions were asked. But everybody who practices consular processing for family-based immigration through Ciudad Juarez, right, in Mexico, knows that this is not how they're looking at things anymore at the Department of State. They are pretty much disregarding co-sponsors who are not close relatives. They are
Yeah.
suddenly looking at whether or not your US citizen children have Medi-Cal, even though historically, we said US citizen children have a right to access public benefits, no questions asked. We don't hold that against the parent for public charge issues. So I am, despite your introduction to me as a constitutional scholar, administrative law is not actually my forte. But I'm really thinking a lot about how I might use this case, this decision, to push back against these sudden changes in policy that really do disrupt expectations.
Yeah. I mean, that's exactly what they're doing, because and this is the worst part of it for the administration, because there's certain things they statutorily can't change without the help of Congress. But regulatory stuff, the branches, State Department, Department of Justice, DHS, all of them could tweak this stuff. Department of Labor all of a sudden is getting more enforcement actions going. There's all sorts of changes happening. That's the loose end where they could push things on. A consular is probably the worst of the whole system, because they can get away with anything. And I mean, there was a story a colleague posted that she had a client that had $1 million in cash, and they were trying to use assets for the affidavit of support in some Central Asian country, and it was denied, even though proof of $1 million in assets were there. And so it just becomes like, what the hell is going on, and how they're interpreting these kind of things.
Yeah, I mean, I'm not sure we're never sure anymore how we deal with all of these shifting interpretations. But maybe this case is going to help us.
Yeah, hopefully. I'm not optimistic, but they'll find a way to hurt us with it.
I think you're going to have to take up federal litigation now, John.
Oh boy. So, I mean, I was hearing that Chevron deference might be on the court's caseload that they were talking about. I'm sorry?
Chopping block?
Chopping block, that's the proper word for it. But if I see they're pro Auer deference, I'm guessing Chevron's going to be the same fate.
Yeah, I mean, so they didn't get rid of, they definitely didn't get rid of agency deference altogether. But I do think this decision really substantially narrows the circumstances in which the government is going to successfully be able to invoke agency deference. And I don't see any reason that the same argument shouldn't apply to Chevron. So yes, this was the case where everybody was hoping Chevron was on the chopping block, or at least everybody in the immigration world.
Mm-hmm.
It's a funny circumstance, because in general, agency deference is probably a good thing in places like the Environmental Protection Agency or the Food and Drug Administration, right? I probably want the scientists at the EPA to be interpreting, particulate matter measurements or whatever it is that they, that you may have agency deference questions on, for environmental purposes. But in the immigration world, the agency is out of control, and so we never want them to get a deference.
Yeah, it's politicized. There's all sorts of other factors that come into place rather than like a hard science area.
Yeah, exactly. So I think, Chevron's not going away. It's still going to be there, just like Auer deference and Brand X, which is another form of agency deference that applies in certain situations. But, I think if we're litigating these issues and we don't believe that the agency's interpretation should be deferred to, either because we don't think we're dealing with an ambiguous statute or regulation, or because we don't think that this is an area where Congress really intended agencies to have deference, I think we have really good arguments now from Kaiser that we can look to for persuasive authority on why places where agency deference has historically existed in the immigration world shouldn't exist anymore.
So it'd be like taking immigration facts and working our way up the judiciary up to the Supreme Court, and then they would kind of get stuck over this whole issue of, yeah, FDA makes sense, but immigration it doesn't. So then they'll have to bifurcate the system and kind of they make it more complex in the sense and say, okay, for immigration we'll do it completely differently or something. Do you think like something like that would happen?
I don't know. It's worth a try.
Yeah, definitely.
I mean, maybe we can get the Supreme Court to just determine that there's pretty much nothing in the Immigration and Nationality Act and the 8 CFR that is somehow more suited for agency interpretation than judicial interpretation.
Yeah, I mean,
I could get behind that as a new standard.
yeah, maybe the medical checkup for family-based cases, or just immigrant visas. What is it? Public health, public that kind of stuff, or what? I can't remember what the terminology was for I-693s, because that might be a
Oh,
medical
the
kind of
medical,
thing.
yeah.
But yeah, everything else is just like on a whim. So it's in legal definitions that, our definitions of words are completely different from the population. So we have our own way of doing things, but it's lawyer stuff. It's not technical stuff. Very interesting stuff. So there was another case that popped up where, kind of briefly, it's unrelated to this. The BIA said that if a person files for asylum just for the sake of getting into court, and then they go
Yeah.
into court, the judge could shut that down. It was a really weird situation because DHS was arguing, or ICE was arguing, that they should stop the proceedings when usually they're the one who want to push the proceedings forward. So they didn't want to
I
go in
know.
proceedings. Yeah. So it's kind of a bizarre situation. But that again would that be a kind of agency kind of decision? I mean, that'd be BIA making a decision of how that's interpreted, despite the fact that for years that was okay depending on which judge got it. I'm not sure it fully fits that, but of Auer Deference and what we talked about earlier. But any thoughts on that decision?
Well, that's an interesting. So I hadn't thought of it from that perspective. Now I'm thinking about it some more, right? So there was a regulation that was at issue in that decision, right? It was 8 CFR 239.2, which is the area in which talks about when you can dismiss a notice to appear, right? When the judge could dismiss a notice to appear.
Mm-hmm.
And they relied on the subsection that says that you could dismiss it when circumstances of the case have changed after the notice to appear was issued to such an extent that a continuation is no longer in the best interest of the government. It's a really interesting question. If we want to talk about where the interpretation would have been disputed, right? It says here, circumstances changed after the notice to appear was issued. By definition, in these cases, the notice to appear isn't issued until after the asylum case was filed, with
Mm-hmm.
whatever purpose the person had in mind by filing it, or their attorney, or the notario, or whomever filed it on their behalves.
Mm-hmm.
And that was discussed, in the case, right? I think that was an argument that was made by the respondents' counsel in this case, which, by the way, was called Matter of Andrade Hasso and Matter of Carbajal Ayala. And the Board of Immigration Appeals, they found a way around it, right? So what they said was the respondents' withdrawal of their asylum application at the first master calendar hearing constitutes a change in circumstances that occurred after the issuance of the notice to appear. So they had to find something that happened after the notice to appear was issued in order to invoke this regulation. So, from a strategic and tactical standpoint, you just shouldn't ever withdraw the I-589.
Yeah, that just keep the
Unless
case going. Go ahead. I'm sorry.
Yeah, unless it's like, and I mean, I think even if it's patently wrong, don't withdraw it, just file a whole bunch of amendments.
Yeah, a weak case at the most, and I mean, don't do fraud or something, but just have it be extremely weak, so it'll get denied. But who cares? That's not your defense that you're going to be arguing.
Exactly, right? I mean, if people, I think, I always thought this was a questionable practice to begin with, filing
Mm-hmm.
asylum applications for the express purpose of getting people into proceedings to apply for cancellation. But if, leaving the ethics of that aside, if practitioners are still going to do that, then I think, you have to keep it in the record. Otherwise, you may find yourself facing this issue.
For many years, that was a practice, and I remember being at ZLA. ZLA is Anaheim's code name for the Anaheim Asylum Office. Someone asked, "Could we do that?" Like, this was like 5 years ago, and they just like were they were like la 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 la, like don't ask, don't tell kind of situation.
Yeah.
And so that was practice, and people would do that, and so it's bizarre for them to all of a sudden change it. That's why sometimes I wish they would just announce something, even if it's something that's bad. I would just make an announcement, let us know, so we don't file cases. I mean, not this kind of stuff, but again, to business cases where we have an expectation that they're going to interpret like for a criteria for extraordinary ability being such and such. And then one day they're like, no, we don't consider, being on the board of a editorial magazine as, judging other people's work or stuff like that. And it's really officer by officer basis, but so it changes so much. I was going to go into a specific case I had, but it's too much confidential information. So that's another time. But I mean, the BIA also had, I'm sorry to keep you, keep you
No,
on the
that's
line,
okay.
but they had another decision. It wasn't BIA, it was Justice Department, which announced that, is this correct? Because I kind of skimmed this stuff, but I just leave it to ask you when I meet you. But they said that the BIA could just issue one-man decisions without any explanation of how they came to a decision. Is that the
Oh
new
God.
thing?
Yeah, it's the return of the streamline denials, right? So these were super popular when Ashcroft was the Attorney General. You'd literally just get a one sentence thing back that says the board affirms the decision below without opinion. I actually got one on a bond appeal um, like a year and a half ago, and I thought, oh my God, this is it. The Trump administration has brought back the streamlined, denials, the
Mhm.
streamlined dismissals. I haven't seen any since then, so I may have been prematurely jumpy, but it does seem that William Barr intends to revive this particular practice.
So it's yet to be seen how widespread it's going to be. Like, is it something that they're going to do just to get the caseload? Because there's probably a million BIA cases where people just file to file. They're trying to like unload those.
I don't know what they're thinking. I wasn't practicing under the Ashcroft administration, or under the when Ashcroft was the Attorney General, I
Hmm.
should say. My understanding is, at least here in the Ninth Circuit, the federal court looked very poorly upon those decisions. Um, those streamlined dismissals. They don't provide much in the way of uh, you know substance for appellate review.
Hmm. So interesting times. I mean, how many more years are we going to have these kind of Department of Justice people? When's election year?
Well, I guess we'll have to see how the next election plays out, right? The 2020 election.
Yeah. 2020,
Cross our
sorry,
fingers.
20. Yeah. So we'll see. Hopefully this is the worst of it, but we'll see what happens. But it's get so many people into it and involved, and it's so lively into getting involved in immigration law and challenging this stuff. Did you go to AILA National this year?
I did. I was actually on the planning committee for this past conference. I'm on the committee again to plan next year, so I'll be back in 2020 for San Diego.
Oh, wonderful. So how was the mood? From what I hear, is federal litigation was the main topic there. But how was your feeling about the conference?
I mean, I always love going, both because I feel like every year I walk away with at least one or two new ideas
Hmm.
for things I should do in the office, things I should screen for, things I should sue over. Um, you know, and I also just enjoy the camaraderie, getting to see my colleagues from across the country. Absolutely, federal litigation was a very popular topic. They had multiple panels you could attend on the topic, and they were all very well attended. It's so much so that we've actually, we're planning next year's and already, and federal litigation is once again going to be a front and center thing
Hmm.
for people to go to panels on, and I think they're gonna, you're probably going to see a lot of folks that don't litigate going to these things, right? People who have been strictly business immigration practitioners who are so fed up with the denials that you were describing, right? People who have historically only done family-based immigration but are tearing their hair out over I-130 denials, and things that get stuck at consulates, and all of the nonsense that we have always dealt with, but that seems to have been just amplified by
Hmm.
tenfold into this administration.
Yeah, it's causing people to kind of lose their fear. There's not just lawyers and clients as well, and being like, you know what, it seems like this is what we have to do. So there's always going to be, the pendulum swings. But they go to one extreme, there's going to be pushback, and there's a wave coming. I mean, people are getting riled up. I mean, look at me, I have a show where I'm dedicating like half the episodes now just on federal litigation topics, and so I mean, you got to be careful what you wish for, and when you get these kind of people in charge and these kind of decisions coming. And it's interesting, like this is just random, was popping up in my mind, but the DH or USCIS director, or whoever the head is now, Cuccinelli, was on one of these news broadcasts, and again, it's not completely unrelated, probably what we're talking about, but they kept
Okay.
asking about ICE. And it's so interesting that the public doesn't understand that ICE is a different agency, and USCIS is supposed to be a benefits-based agency. So they kept
Right.
asking about, what ICE is going to do to pick up people that are out of status and that, and expecting him to give a statement. But it just shows him that the people, the reporter didn't do the research to know that he's not ICE. He is not in charge of enforcement. So anything he said is just,
Although sometimes we feel like he must be anyway.
yeah,
Just
yeah.
the environment at USCIS is so enforcement based now, we might as well be working with ICE.
Yeah, if they could have made this guy a DHS head, I'm sure they would, but I don't think Congress would pass it, or they couldn't, the too much bad blood would come up if they made this guy the head of DHS. I mean, that's the thing. So, but it's going to force more education in the public about ICE and what they're doing, and what USCIS is doing, changing from what's supposed to be a benefit and service-based agency to some sort of fraud detection unit, which is, I mean, part of their duties, but frankly, it's not the main part of their duty. There's sub agencies that could do that. The facts are that people are talking about this stuff. Hopefully that's a benefit. And the more we as immigration lawyers could control the debate or help to talk about it, it'll help a lot. Because as every immigration lawyer knows, whenever we talk to anybody who doesn't practice immigration law about anything immigration related, it's 99% wrong. Like, so they just, nobody knows what's going on except for people that are actually doing it. Even me, I'm afraid to talk about BIA stuff and stuff because like, it's so complicated. I don't even want to do it, even though like I'm on this stuff all day, reading it and teaching it. It's such a expertise that's required to know this stuff and how to do it.
Absolutely.
Yeah.
I wouldn't step into your shoes and file an L whatever 1, 2, 3, 4, 5.
I mean, even with my expertise in it, studying it all day, now I'm even getting afraid of filing it because I know which way it's going to go. So you have to have a litigation plan lined up from the beginning. So in the first consultation, be like, just be prepared to have a fund for litigation because that may be required from if you're a solo, like not a solo, like if you're a small firm making a small business in the U.S. or even if you're, a big corporation, one of the big names that have big stocks. The litigation is going to come part of it if you want to be successful. Immigration and litigation are going to be synonymous in the next decade, it seems.
Oh,
yeah, it's a crazy phenomena.
I mean, I'm happy to learn district court work, which I've had the opportunity to, start learning with a lot more vigor under this administration. But I hope we won't actually be in a perpetual state of having to sue over everything.
I think it's going to have to get like that until they back down because it's no one's going to like it. It's just going to be annoying for everybody. But I feel like the other side just needs to know, like, come on, be reasonable, or else there's no choice to do with stuff like that. And it's going to further bifurcate just society into the pro and anti groups and stuff. So it's just going to make things worse. There's got to be some sort of meeting of the minds and something. I think it goes to really foreign policy in the U.S. and drug policy and medical policy about how we deal with stuff overseas. It won't be a court or immigration thing that would solve this. It's like how we deal with, Central America and South America as being within the sphere of influence of the United States. And if someone doesn't completely fall in line with our goals, are we going to demolish their economy and their governance so that people have to flee or not? Or are we going to keep, banning certain drugs or just all drugs so that Mexican drug cartels go run havoc? Or a myriad of other things we do internationally that causes immigration. Like when you look at Syria, our decision to go in, I mean, it's illegal. Like we invaded a country, put troops there without permission. And that causes the refugee crisis within Europe. And it really has hit us because we're, oceans apart. But if you look at immigration and refugee policy, we had a direct hand in the creation of this craziness that led to mass movements of people from Libya, from Syria, all these people flooding into Europe. And then Europe has immigration issues and they blame the immigrants, but they don't blame the cause. They just blame the effect. So practitioners, if we're going to do stuff, it's really got to vote. When we look at elections, unfortunately, foreign policy never gets talked about, and it's just something that's thrown to the side. When you look at the Democratic debates, only Tulsi Gabbard actually had an explanation of this stuff. Everyone else just was like, free Medicare, free school, free this. I'm like, well, we got to talk about foreign policy. And that's something that no one touches, even though it affects the finances of the country and the immigration policy of the country. That's sorry, ex-political scientist jumping in, but that's still in my mind every time I see these problems. We can't solve it by changing the INA or CFR. This has really got to be solved on a human level with bilateral relationships with countries.
Yeah, well, here's hoping.
Well,
here's hoping for an improvement in international relations, immigration policy in the United States, statutory and regulatory interpretation by this administration, all of the things.
Yeah, I think in the bigger picture, it's got to be like this massive human evolution that happens where people have better understanding, something that we can't even foresee, or else we're just going to all destroy everything. So evolution is the process, and sometimes evolution has to happen through massive pain before people evolve, and hopefully evolve for the better, and it will solve the problems. But that seems like what we have to do is really evolve and figure out what that means. But thank you so much for coming on board and talking with us. I look forward to talking with you again, Sabrina. Thank you.
You too. Thanks, John.